So let us start with this Contract Act first. So what it says in Contract Act, how this process starts. So first of all, there is a proposal by one person, which is called the offer. And when it is accepted by the other person, it becomes a promise. And when the other person promises something in return, so that is called consideration. So any idea as to what is quid pro quo? ये क्विड प्रो को का क्या होता है?
Something in return.
Yes, something in return. बिल्कुल ठीक है. तो ये जो है, this is also consideration. ये जो consideration है, so consideration is a quid pro quo, something in return. Very good. Now when two people promise to each other, so that becomes an agreement. Now this agreement may or may not be enforceable at law. So if it is an enforceable at law, it becomes a contract. So whether social agreements are contracts or not?
No, sir.
No, social agreements are not contracts because they are not enforceable at law. Now, what are the essential elements? Let us quickly cover what are the essential elements of a contract. So first of all, there has to be plurality of persons. Whether a person can enter into contract with himself, the answer is no.
No.
Consensus ad idem. What is this consensus ad idem?
Same thing in same sense.
Yes, meeting of minds. So when one person is saying, the other person is understanding it in the same sense. So that is consensus ad idem. Legal intention. So the parties, they intend to create a legal relationships. So that is why agreements of social or domestic nature do not contemplate legal relationships. Lawful consideration. The agreement must be supported by a lawful consideration. Whether consideration need to be adequate, is it important that it is adequate or even inadequate consideration could be there?
Inadequate can also be there.
Yes. So it is not important whether consideration is adequate or inadequate. Something in return may be an act or abstinence also. So it could be both ways. Either he is doing a positive act or he is promising to abstain from something. But consideration must be real and lawful. Then capacity to contract. Capacity to contract is also important. He shall not be a minor.
मम्मी पापा लेंगे चाय?
He shall be of sound mind. Shall be disqualified from contracting by to which he is subject. Take it. So whether there could be a contract with a minor. माइनर के साथ कॉन्ट्रैक्ट हो सकता है या नहीं हो सकता, या किसी भी सिचुएशन में नहीं हो सकता?
नहीं हो सकता सर.
There can be a contract with a minor, like minor can be admitted to the benefits of a partnership. So if the agreement is for the benefit of the minor, that could be there.
So same is for sound mind also, unsound mind. जैसे माइनर के फॉर द बेनिफिट ऑफ माइनर वी कैन हैव
कॉन्ट्रैक्ट नहीं होगा एक्चुअली. माइनर में क्या है, वो एग्रीमेंट्स बाय नेसेसिटी में कवर हो जाते हैं एक्चुअली एग्रीमेंट्स. अदरवाइज जो है, इफ देयर इज नो कैपेसिटी टू देयर इज नो कैपेसिटी, देयर इज नो कॉन्ट्रैक्ट. But agreements with minor are on a different footing, because if it is advantageous to the minor, like suppose a minor is being admitted to the benefits of the partnership, then to that extent he can enforce his rights.
Okay.
Lawful object. So the object of the agreement must be lawful. Certainty and possibility of performance. Then legal formalities. Suppose there are some legal formalities like registration, etc. So that should also be completed. So general rule is that a stranger to a contract cannot sue. So if you are not a party to the contract, you cannot sue. But there could be certain exceptions. Suppose you are a beneficiary in a trust. So then you can sue that trust for those benefits. In case of family settlement, suppose your name is appearing in the family settlement that, okay, you are entitled to this part of the property, movable or immovable, then you can sue that on that account. Contract by agent. So contract with agent is as good as contract with the principal. Acknowledgement of debt and covenants attached with immovable property. So these are the exceptions where even a stranger to a contract can sue. Otherwise, the general rule is that a stranger to a contract cannot sue. Now, let us see these types of contract on the basis of extent of execution. One is executed, that means both the parties have fulfilled their part of the promise. Executory, both the parties have yet to perform their part of the promise, and it could be partly executed or partly executed. Then contingent contract. Contingent contract is a contract to do or not to do something. If some event, collateral to such event, does or does not happen, like insurance contract. All insurance contracts are contingent contracts. So we can understand these contingent contracts by way of examples. So what it says, suppose a contract is dependent upon the happening of an event. So in such a case, if such event has happened, then that contract can be enforced. So A makes a contract to buy B's house if A survives C. So this contract cannot be enforced by law unless and until C dies in A's lifetime. And if A dies before, then it becomes void. Second is, similarly, there could be a contract which is dependent upon non-happening of an event. Like in case of shipping contracts, if A contracts to pay B a certain sum of money, if a certain ship does not return. So in that case, this contract will be enforceable when the happening of such event has become impossible. That means that ship has sunk. And it will become void when such event has happened. Sometimes the contract is made contingent upon happening of an event within a specified time. So it can be enforced when such event has happened within specified time, and it becomes unenforceable when the happening of such event becomes impossible. Similarly, there could be a contingent contract which could be dependent upon non-happening of an event within a fixed time. So these are the various types of contingencies upon which the contracts may or may not be enforceable. In case of joint liabilities, so what happens? When two or more persons have made a joint promise, then unless a contrary intention appears by the contract, the following persons shall fulfill the promise. First of all such persons during their joint lives, if all of them are living, then all such persons during their joint lives, and after the death of any of them, his representative jointly with the survivor or survivors. And after the death of the last survivor, the representatives of all jointly. Okay. Any one of the joint promisors may be compelled to perform by the promisee. So when two or more persons make a joint promise, the promisee may, in the absence of express agreements to the contrary, compel any one or more of such joint promisors to perform the whole promise. Depending upon the breach of contract, there could be different types of breaches. One could be anticipatory breach, other could be actual breach. Anticipatory breach is when a party refuses to perform the contract before the time fixed for its performance. Or second is when a party by his own act disables himself from performing the contract in its entirety. For example, A has contracted that, okay, I will sell my car to B. But before the agreed date, A sells the car to C. So then car cannot be sold to B. So it is anticipatory breach. Then what are the rights? So these are described the rights what are there in case of anticipatory breach. Actual breach is, it is a case of refusal to perform the promise on the scheduled date or during the performance. There are different effects of actual breach. One could be rescission of the contract. The other party is at an option to rescind the contract. It may sue for damages. It may sue for specific performance. There may be suit for injunction. There may be suit for restitution. And there may be suit based upon quantum merit. What is this quantum merit? As much as is earned. Suppose you engage a painter. You engage him on a daily basis. But after lunch, you ask him that, okay, I have to go somewhere. So now your services are no more required. So you have to pay him for the work he has done. That is the concept of quantum merit. So quantum variant means as much as is earned or according to the quantity of work done. There are two types of contracts, contracts of indemnity and contracts of guarantee. So in this case of contract of indemnity, there are two parties, indemnifier and indemnified. And this contract of indemnity is basically for the promise done to save the other party from the loss. So loss may be caused by the conduct of the promisor or by conduct of any person. So in this contract of indemnity, there are two parties. One is the indemnifier who promises to make good the loss, and the other party is the indemnified. His loss is to be made good. But in case of contract of guarantee, there are three parties. One is the principal debtor, second is the creditor, and third is the surety. The liability, primary liability is of the principal debtor. Suppose A has taken a loan from B. Now A is the principal debtor and B is the creditor. But C guarantees that okay, in case A doesn't pay, then I will pay. So C will become the surety in this contract. And there are three separate contracts in case of contract of guarantee. One is the contract between the principal debtor and the creditor. Like the example I gave, A has taken loan from B. So A is the principal debtor and B is the creditor. Second contract is between the surety and the creditor. So second contract is between B and C. So C is the surety and B is the creditor. And third contract is between the principal debtor and the surety. So once the surety pays, it steps into the shoes of the creditor and he has the right to recover the money from the principal debtor. Now this bailment and pledge. Bailment and pledge is also one of the important aspects. So we'll do a case study on this also on this bailment. Another important concept in case of contracts is creation of agency. So agency could be by an express agreement, by implied agreement, by ratification after the work is done, or by operation of law. Okay. And in case of implied agreement, it could be by estoppel, holding out, or agency in case of necessity.
So what is the difference between estoppel and holding out?
Estoppel is actually if you have made a positive affirmation, two persons are sitting on a shop, a customer comes and A introduces B as his partner. So then he is stopped from holding out that he is not the partner. That is the concept of estoppel. Holding out is by action basically.
Okay.
And necessity is in case, suppose the landlord of a property is living in a foreign country. Now a notice comes from the municipal corporation that okay, in case you do not pay the municipal taxes by this date, so then your property will be put under lock and key. So in that case, the tenant pays the municipal taxes dues because he could not contact the owner of the property, which is living abroad. So in such a situation, what will happen? This is a contract by necessity, agency by necessity.
Forgive everything, forget everything in the past. You all have to work together, work for each other.
Now let us do this case study. This case study is based on the concept of contracts. There are different concepts in case of contracts. So the communication, because we have seen, ये
So it is
आपके
little
यहाँ से
noise.
कुछ आवाज आ रही है, म्यूट कर लीजिए अपने को प्लीज. कहीं से भी आवाज आ रही हो ना, मैंने कई लोगों को कोस्ट बनाया हुआ है. भाई कोस्ट का काम ही यही है, अगर कहीं से आवाज आ रही है तो आप उनको म्यूट कर दीजिए दूसरे को. ठीक है, ओके. So Mr. Anshul has applied for a job as principal of a school and the school management decided to appoint him. One member of the school management committee privately informed Mr. Anshul that he was appointed, but no official communication was there in this case. So in your view, whether official communication is necessary or not?
It's necessary.
Yes. Later, the management of the school decided to appoint someone else as principal. Okay. But in this case, one member of the school management committee privately informed Mr. Anshul that he was appointed, but official communication was not given. So whether this private communication between one member of the school management and Anshul, whether it holds any authority or not.
It does not hold authority. It is
Yes.
privately.
Yes.
the school.
So, but Mr. Anshul filed a suit against the school for cancellation of his appointment and claimed damages for loss of salary. So can he claim so?
No, he cannot.
No, he cannot claim. So on the basis, first is what is the position of Mr. Anshul in this case? Because Anshul responded to an advertisement. So Anshul is offerer, offeree, promisor or promissory?
Offering.
Offering, yes. Because he is offering his services. And who is the offerer in this case?
School management.
Offerer is school. Yes. So he is,
Yes, sir. Anshul will be offerer, sir. He's offering for his services.
yes. Oh, sorry. Yeah. Anshul is
okay.
offerer. Anshul is offering his services. Anshul is the offerer, and to whom the services are being offered, services are being offered to the school. So
Management.
school is the school management or school is the offering. So whether it is say general offer or a specific offer,
Specific offer.
it is a
Specific
specific offer because I think
Hmm.
what is the type of offer? Whether it is a cross offer, standing offer, general offer or special offer. So it is in the nature of a special offer. What is cross offer? Any idea?
Yes, sir. Cross offer.
When I
is-
tell, sorry.
Cross offer is suppose, sir, I give an offer, X gives an offer to B for one thing and B also give the same offer to A without knowing that he's giving this offer. So they cancel each other. That is a cross word is used, sir.
Hmm.
Like A wants to say that I want to sell my house at rupees 50 lakh. Now B
Hmm.
wants to say that I want to buy your house at 50 lakh.
Mhm.
But this is the same offer given. So this becomes the cross offer.
Yes. And what is the standing offer?
So standing offer is till a particular period it is given, sir. Like
Yes.
the
Suppose
sale
you go
comes
to a
in-
market and on the market various wares are displayed and along with each item the price is also displayed. So till the display is there or unless some conditions are written, it is a standing offer. So anyone can pick up that ware, he can pay for the price and take it. So that is in the case of a standing offer. You go to a say mall, so there are various shirts, trousers displayed. So it is in the nature of a standing offer. Whether private information by one of the members of the management amounts to acceptance?
D,
Because in
sir.
this case, the school, one of the members of the management committee informed him privately, but there was no authorized communication. So whether it amounts to acceptance of the services of Mr. Anshul by the school management or not?
D, sir. No, he was not an authorized
Yes.
person.
So communication of acceptance, there is a rule that it should be either by the offeree himself or his authorized agent. That means it should have been done either by the school management or by its authorized agent. Whether the suit filed by Mr. Anshul is tenable?
B.
No, yes. No, as it is not a valid contract. Rishabh, a minor, falsely representing his age, enters into an agreement with the shopkeeper for a loan amount for purchasing a laptop. He gave his expensive watch as a security and took a loan of 70,000 rupees. He purchased a laptop worth 63,000 and happily spent the rest of the amount with his friends on a treat. Later on, he realized that his watch was an expensive watch and he should not have given like this to the shopkeeper. So he went back to the shopkeeper and asked for his watch back. However, he refused to pay the loan amount. The shopkeeper disagrees to this and files a case against minor for recovery of the loan amount. So this case study is based on the contract with the minor. A minor is not competent to contract into any contract. This provision is contained in section.
Suppose 10, sir.
Yes. Section 11
11.
में दिया।
11.
Can Rishabh be forced to repay the loan amount?
No, sir.
No.
Hmm. Can shopkeeper file a case after 3 years when Rishabh becomes a major? अभी तो माइनर है, बाद में मेजर हो जाएगा ऋषभ, तो क्या मेजर होने के बाद में केस फाइल हो सकता है या तब भी नहीं हो सकता?
No, sir. नहीं हो सकता.
No, ratification is
ratification.
not possible. Will Rishabh get his watch back? ऋषभ को क्या अपनी वॉच वापस मिल जाएगी?
Sir, third का आंसर देखें सर, क्या लिखा? Third वाला.
No ratification is not possible.
ऋषभ को अपनी वॉच वापस मिल जाएगी या नहीं? क्या होगा?
I think D, sir.
Yes, it is void ab initio B आना चाहिए.
तो void ab initio
B is the answer. Yes.
अच्छा, yes. Okay.
Hmm.
Sir, it will be yes.
yes.
Okay.
ये जो है ना, मिल जाएगी वापस. Rachna arranges an auction to sell an antique work clock. Meghna, being one of the bidders, gives highest bid. For announcing the completion of sale, the auctioneer strikes the hammer on the table, but suddenly hammer breaks and damages the watch, which is lying near the table. ठीक है, उसने ऐसे हैमर मारा तो क्या हुआ, हैमर वॉच के ऊपर गिर गया और वॉच जो है डैमेज हो गई. मेघना wants to avoid the contract. वो कहे भाई मैं टूटी हुई घड़ी क्यों लूं? तो क्या है ये? What kind of contract is this?
Voidable contract, I think.
Implied contract.
Implied contract है, because in case of auction, it is an implied contract that as soon as the hammer falls on the table, so the contract is said to be completed.
Sir, it can also be voidable, no? Because
Voidable, in case of voidable, the conditions are different. If a contract is induced by, say, fraud, misrepresentation, undue influence, so in that case,
only in those 4 cases, sir, it is
yes,
voidable.
yes. In those 4 cases, it is voidable at the option of the person whose consent was so obtained.
Okay.
So what is the position of the auctioneer?
Auctioneer is always the agent of seller, sir.
Agent of seller.
बिल्कुल. Can Meghna retract from the bid? मेघना बोल रही है मैं तो वॉच नहीं लेती भाई, ये तो टूट गई अब. Answer will be C. As the hammer has fallen, so as soon as the hammer falls, the contract is complete. Who shall bear the loss in this case? Loss किसका होगा?
Meghna.
मेघना का.
Hmm.
Akshay purchased a refrigerator from Jethalal, the owner of Gada Electronics, on the condition that first 3 days he will check its quality, and if satisfied, he will pay for that. Otherwise, he will return the refrigerator. ठीक है? इसने बोला भाई देखो ऐसा है कि मैं 3 दिन इसकी क्वालिटी चेक करूंगा, अगर सही होगा तो मैं ले लूंगा, अदरवाइज आई विल रिटर्न इट. सेकेंड डे को क्या हो गया? रेफ्रिजरेटर खराब हो गया. अब जेठालाल क्या कह रहा है? जेठालाल कह रहा है भाई मेरे को तो पैसे दो. आपके हिसाब से क्या होना चाहिए? जेठालाल को पैसे मिलेंगे, नहीं मिलेंगे, क्या होगा?
मिलना चाहिए सर, ये कंडीशनल कॉन्ट्रैक्ट है.
हाँ तो 3 दिन में क्या था ना, तो दूसरे दिन खराब हो गया ना.
Sale
हाँ,
and
तो
return, sale on return basis तो नहीं मिलेगा सर.
हाँ, क्योंकि दिस इज ए कॉन्ट्रैक्ट ऑफ सेल और रिटर्न बेसिस. उसने कहा ना मैं रिटर्न कर दूंगा अगर 3 दिन के बाद, 3 दिन में अगर सेटिस्फाइड हुआ तो अदरवाइज आई विल पे, अदरवाइज आई विल रिटर्न. तो 3 दिन से पहले अगर कुछ खराबी आ जाती है तो इट इज टू दी सेलर. What type of agreement is this? Sale, agreement to sell, sale on return, credit sale?
Sale on return basis.
Sale on return. ठीक है. Whether Akshay is liable to pay the price under the Sale of Goods Act?
No.
B.
Property does not cost.
Yes. Who will ultimately bear the loss?
Jethalal.
Jethalal.
According to section 24 of Sale of Goods Act, the property passes to the buyer.
D, I think.
Yes, D should be the answer. Because can you give an example of A when it signifies his approval or acceptance to the seller? Suppose Akshay goes to the shopkeeper on the second day itself that okay, fridge is very good, and he pays. And when he comes back, he realizes that it has been damaged because of voltage fluctuations. Then what will happen?
Once he has given consent, acceptance, then he cannot return.
Yes. So the contract is complete. The property passes to the buyer. So when this is the example of when it signifies his approval or acceptance to the seller. Second is when he does any other act adopting the transaction. Suppose a trader has purchased goods from a seller, and that trader again sells those goods to some other party. So that is the example of doing any other act adopting the transaction.
Sir, ये जेठालाल के case में if he does not come back only after 3 days, then it will fall under B.
Suppose नहीं, if he नहीं 3 दिन के बाद तो he is liable to pay the price. After 3 days he is liable to pay the price.
नहीं, पर वो अगर if he wouldn't have gone back only to tell him any defect, तो वो does any other act में हो जाएगा क्या?
Yes, हाँ, बिल्कुल बिल्कुल बिल्कुल. Only for 3 days Jethalal was required to wait. Otherwise, if he has kept the goods say on 4th day also, so then he has done any other act adopting the transaction. Third is if he doesn't, वो यहाँ पर आ जाएगा ना second में. If he doesn't
Actually, C में
signify
आ
his
जाएगा.
approval, third point में आ जाएगा. Or acceptance to the seller, but retains the goods beyond a reasonable time. Suppose 3 days was the time in this case. Now he retains the goods for say for a week. So then, because he was required to signify his approval within 3 days, है ना? But he has retained the goods beyond a reasonable time. So in that case also, the property has passed to the buyer. Now Sethi drew a check for rupees 2 lakhs payable to Vishnu and delivered it to him. ठीक है? ये negotiable instruments act पर based है. तो Sethi drew a check for rupees 2 lakh payable to Vishnu and delivered it to him. Vishnu endorsed the check in favor of Ayansh, but kept it in his table drawer. उसने endorsement कर दिया in favor of Ayansh. ठीक है? चेक ड्रॉ किया है किसने? ड्रॉर कौन है इसमें? इसमें ड्रॉर कौन है? ड्रॉर है सेठी.
सेठी.
और ड्राई कौन है?
विष्णु.
नहीं, ड्राई कौन है? ड्राई तो बैंक है. चेक के केस में ड्राई हमेशा बैंक होता है. और पेई कौन है? पेई विष्णु. है ना? क्योंकि बिकॉज द चेक इज ऑलवेज ड्रॉन ऑन अ बैंक. बैंक ही तो पेमेंट करेगा ना उसकी. तो विष्णु एंडोर्स द चेक इन फेवर ऑफ अयांश बट केप्ट इट इन हिज टेबल ड्रॉर. उसने एंडोर्समेंट कर दिया अयांश के फेवर में, लेकिन अपनी टेबल ड्रॉर में रख लिया. सब्सिक्वेंटली विष्णु डाइड. ठीक है? एंड चेक वाज फाउंड बाय अयांश इन विष्णुज टेबल ड्रॉर. ठीक है? नाउ अयांश फाइल्ड द सूट फॉर द रिकवरी ऑफ द चेक.
Endorsement and delivery should be the answer.
Yes, endorsement and delivery. Now suppose Ayansh was minor and it was duly delivered to him, तो क्या होगा?
Ayansh was minor. Void but enforceable होगा sir. नहीं valid होगा sir ये.
Valid हो जाएगा because it is for his benefit.
सर क्वासी कॉन्ट्रैक्ट क्या है एक्चुअली?
Quasi contracts पे क्या होता है? One of the party is major but the other party is not in a position to do the contract. Quasi contracts में ये minor contracts with minor है ना, या contracts in case of necessity. जैसे मैंने आपको बताया कि वो जो municipal taxes, payment of municipal taxes by the tenant in case he is not able to trace the owner. So all these are in the nature of quasi contracts. So quasi contracts are there where one party is, although there is no express contract between the two parties, but it is said to be an implied contract. ये quasi contracts में होता है कि the other parties has to pay. Suppose a miner buys the goods for his necessities, so he is required to pay for his necessities. To that extent, it is a quasi contract. Validity period for presentment of check in bank is
3 months.
3 months. पहले 6 months होता था, अब 3 months. What if Rohan, legal representative of Vishnu, delivers it to his friend Renu? अब जो विष्णु की तो डेथ हो गई है, ठीक है ना, तो रोहन ने क्या किया, रोहन ने अपने फ्रेंड रेनू को दे दिया
ये इनवैलिड एक्ट होना चाहिए सर, बिकॉज ही कैन नॉट डू इट.
अब इसमें क्या है, मैं थोड़ी कहानी समझा देता हूं आपको कि श्यामा प्रसाद एंड चिरंजी लाल आर, दिस इज ए केस स्टडी ऑन बेलमेंट आई थिंक. तो श्यामा प्रसाद एंड चिरंजी लाल आर फ्रेंड्स, बोथ आर डूइंग द बिजनेस ऑफ इंपोर्टेड फॉरेन मेड कार्स. ठीक है, तो श्यामा प्रसाद ने क्या किया, श्यामा प्रसाद ऑर्डर्ड सर्टेन फॉरेन मेड कार्स. ठीक है, out of 22 cars, 14 cars were delivered to Shyama Prasad in the month of September, and the foreign company promised to deliver rest of the cars latest by December. Okay, payment has already been made in advance. So one day, friend of Shyama Prasad, Chiranji Lal, he came to meet him, and Shyama Prasad showed him his newly purchased foreign made cars. Okay, both are dealers in cars. Chiranji Lal was very much impressed to see all those imported foreign made cars, and he wished to make a test drive of one of those cars. Shyama Prasad made no objection to that, and Chiranji Lal made a successful test drive of one of the newly imported cars. After successful test drive, Chiranji Lal offers Shyama Prasad that he wants to display those foreign made cars at his showroom situated at Greater Noida in order to increase its sale. वो कहता भाई मैं भी कुछ कार जो है अपने शोरूम में रख देता हूँ. चिरंजी लाल ने बोला ठीक है. Shyama Prasad agreed to that proposal, as Shyama Prasad and Chiranji Lal both were old school friends. One day, a fire broke out in the showroom of Chiranji Lal, and nearly 20 cars were completely destroyed due to the cause of fire, out of which 10 cars were that which belonged to Shyama Prasad. तो श्यामा प्रसाद की भी जो 10 कारें थी वो भी जल गई उसमें. Shyama Prasad came to know about the incident, and he demanded compensation from Chiranji Lal for the goods handed over to Chiranji Lal. ये फैक्ट्स ऑफ द केस है. ठीक है, मार्केट प्राइस कितना है, मार्केट प्राइस है 95 लाख, परचेज प्राइस है 82 लाख. ठीक है, चिरंजी लाल has spent a sum of rupees 1 lakh on the goods received from Shyama Prasad. Rent of the showroom where goods were displayed is 5 lakhs per month. ठीक है, the period during which the goods were under the custody of Chiranji Lal is 2 months. इंश्योरेंस कंपनी ने क्लेम रिजेक्ट कर दिया. इंश्योरेंस कंपनी ने बोला भाई दीज वर नॉट द गुड्स बिलोंगिंग टू यू, तो जो चिरंजी लाल का क्लेम था वो रिजेक्ट कर दिया. एंड दे डिनाइड एनी कंपेंसेशन फॉर द गुड्स डिस्ट्रॉयड विच बिलोंग टू श्यामा प्रसाद. तो पहले तो ये बताइए कि ये जो अरेंजमेंट है बिटवीन श्यामा प्रसाद एंड चिरंजी लाल, श्यामा प्रसाद ने फॉरेन कार्स खरीदी थी, चिरंजी लाल ने बोला लो मैं भी अपने शोरूम पे डिस्प्ले कर देता हूं. तो इन दोनों के बीच में जो कॉन्ट्रैक्ट है, ये कॉन्ट्रैक्ट ऑफ बेलमेंट है या नहीं है? Is it a contract of bailment or not?
Yes, there is a
Yes,
contract.
it is, sir.
Yes, it is a contract of bailment. Now, whether a contract of bailment can be gratuitous also?
Yes,
Suppose
Yes, it
you are
can be.
going to a foreign country and you ask your friend that okay, here are the car keys, you take care of my car, बीच बीच में चला भी लेना, वरना मैं तो 6 महीने बाद वापस आऊंगा, पड़े पड़े खराब हो जाएगी, है ना? तो
Right.
it is a contract of bailment.
yes,
Yes.
Yes.
You give your suit for stitching, you give your cloth of suit for stitching to a tailor, whether it is a contract of bailment?
Yes.
Yes.
this is the
So
contract.
all
of
these are contracts of bailment. Now, what should be the amount of compensation in the above case if Shyama Prasad refused to take back the goods escaped from fire? Is he legally bound to take back the goods? क्या पोजीशन होगी? श्यामलाल को लेने पड़ेंगे गुड्स या नहीं?
हाँ, जो बच गए उनको तो लेना चाहिए सर उसको वापस. Those who are safe escaped from
देखिए
fire.
बेलमेंट में क्या रूल रहता है, बेलमेंट में रूल रहता है कि यू हैव टू टेक केयर ऑफ गुड्स एज इफ दे आर योर ओन गुड्स. ठीक है, जैसे आपके गुड्स हैं उसकी जितनी केयर करते हो उतनी ही केयर कर सकते हो आप. अब इसमें फैक्ट्स देखिए आप। अब फैक्ट्स में क्या है, वो कह रहा है 20 कार्स डिस्ट्रॉय हो गई उसमें। 20 में से 10 उसकी भी थी, चिरंजीवी लाल की भी थी, खुद की भी, और 10 इसकी थी, श्यामा प्रसाद की। तो ऐसा तो नहीं है ना कि उसने उसकी कार्स का ध्यान नहीं रखा या उनको अलग से गोडाउन में रखा जहां पर कुछ इनफ्लेमेबल मटेरियल था, ऐसा तो नहीं है ना। तो इस केस में हुआ क्या है, इस कार में ही हैज टेकन एज मच केयर एज वाज रिक्वायर्ड।
सर जो सेफ हो गई उसको तो ले जाएगा ना सर वो?
हाँ
Bailment-
ले जाएगा, बिल्कुल ले जाएगा। हाँ, अब बेलमेंट के बारे में कुछ प्रोविजंस पढ़ लेते हैं, बेलमेंट है क्या एक्चुअली, तब फिर एक और केस स्टडी करेंगे। कुछ कुछ आइडिया आपको हो गया। बेलमेंट इज द डिलीवरी ऑफ गुड्स बाय वन पर्सन टू अनदर फॉर सम पर्पस। ठीक है, अपॉन ए कॉन्ट्रैक्ट दैट दे शैल व्हेन द पर्पस इज अकॉम्प्लिश्ड द प्रॉपर्टी मस्ट बी रिटर्न बैक और अदरवाइज डिस्पोज्ड ऑफ अकॉर्डिंग टू द डायरेक्शंस ऑफ द पर्सन डिलीवरिंग देम। ठीक है, द पर्सन हु डिलीवर्स द गुड इज कॉल्ड द बेलर। जैसे मैंने बताया, मैं अपना सूट लेके जाता हूँ, सूट के लिए कपड़ा लेके जाता हूँ टेलर के पास कि भाई यू स्टिच द सूट, तो मैं क्या हो गया, बेलर, और टेलर क्या हो गया, बेली। द पर्सन टू whom the goods are delivered is called the bailey, and the contract between the bailor and the bailey is called the contract of bailment. ठीक है, so the contract of bailment is created only about movable property। ये इंपॉर्टेंट चीज है कि इमूवेबल कॉन्ट्रैक्ट, इमूवेबल प्रॉपर्टी का कॉन्ट्रैक्ट ऑफ बेलमेंट नहीं हो सकता। ठीक है ना, ये एक इंपॉर्टेंट पॉइंट है।
सर इमूवेबल प्रॉपर्टी का प्लेज होता है?
यस,
Right, right.
मॉर्गेज हो सकता
Mortgage.
है।
हम्म।
Now, bailment is a legal relationship in common law where the owner transfers physical possession of a personal property for a time, ठीक है, but retains ownership. The owner who surrenders custody to a property is called the bailor, and the individual who accepts the property is called the bailee. ठीक है, a bailment can be expressed pursuant to agreement by the bailor and the bailee or implied simply as a result of the parties' conduct. ठीक है, एक्सप्रेस बेलमेंट में क्या है, एलेक्स गिव्स हिज कार टू ब्रांडी टू सेल। ठीक है, ब्रांडी विल रिसीव ए कमीशन फॉर सेलिंग द कार अंटिल द कार इज सोल्ड, दिस सिचुएशन इज अ बेलमेंट। ठीक है, ये बेलमेंट। सो व्हाट आर थ्री टाइप्स ऑफ बेलमेंट्स? वन इज फॉर द बेनिफिट ऑफ द बेलर एंड द बेली, दोनों के बेनिफिट के लिए, फॉर द सोल बेनिफिट ऑफ द बेलर एंड फॉर द सोल बेनिफिट ऑफ द बेली। A bailment for the mutual benefit of the parties is created when there is an exchange of performances between the parties. So bailee is a person who receives property from the owner known as the bailor and holds the property for the owner for a particular purpose. उसको पर्पस क्या हो सकता है, कस्टडी हो सकती है, रिपेयर हो सकता है। ठीक है, मैं एक घड़ी रिपेयर कराने वाले के पास जाता हूँ, वो बोलता हूँ भाई मेरी घड़ी ठीक कर दो, तो ये क्या है, ये भी एक बेलमेंट है। सो बेली इंक्लूड्स दी कोर्ट चेक अटेंडेंट्स, वैले कार सर्विसेज, बैंक्स, ज्वेलर्स एंड ड्राई क्लीनर्स। A bailee assumes a legal and fiduciary responsibility to safeguard the bailor's property while under their care. ठीक है, the person delivering the goods is called the bailor, the person to whom they are delivered is called the bailee. अब there are certain rights and duties of bailor and bailee, वो क्या है वो देख लेते हैं जरा। Bailor has certain rights and also some duties that he has to follow. Rights क्या है, right to get his goods back, ठीक है, right to get the increase or profit from the goods bailed. ठीक है, I give my cow to my neighbor that okay, I am going out for a week. Now this cow gives birth to a calf, so I am entitled to get the calf as well. So that is the increase or profit from the goods bailed. Right to get compensation, right to terminate the contract. In case the bailee has not taken sufficient care, then I have got a right to compensation also. Or suppose I instruct him specifically not to deal the goods in a certain way, then also I am entitled for compensation. What are the duties of the bailor? It is the duty of the bailor to disclose faults in goods bailed. It is the paramount duty of the bailor to express the fault of the goods to the bailee. Duty of the bailor to give compensation to the bailee in case bailee gets some damage because I did not disclose the faults in goods paid, and duty to give expenses. ठीक है, if he takes care of my goods and suppose he incurs some expenses, so then I am duty bound to pay to him certain expenses. राइट्स ऑफ बेली क्या है? राइट्स ऑफ बेली में राइट टू गेट कंपेंसेशन, राइट टू टर्मिनेट द कॉन्ट्रैक्ट, राइट टू गेट एक्सपेंसेस। ड्यूटीज ऑफ बेली क्या है? ये इंपॉर्टेंट है, असली इंपॉर्टेंट, सबसे इंपॉर्टेंट ये चीज ये है, ड्यूटी ऑफ बेली, बिकॉज गुड्स आर इन हिज कस्टडी। तो सबसे इंपॉर्टेंट इसको ध्यान से पढ़ना है। फर्स्ट ऑफ ऑल, ही हैज द ड्यूटी टू टेक केयर ऑफ द गुड्स, he has the duty to return the goods after the complement of purpose. It is the duty of the bailey to return the goods, to make proper use of goods paid. The use of goods which are mentioned under the contract, the use must be according to the contract. Duty not to mix his own goods with the goods of the bailor. Duty not to question the title of the bailor. Duty of bailey to pay increase or profit from the goods paid. ठीक है, for example, A gives a cow to be on bailment, and after the bailment, cow gives birth to a calf. So it is the duty of the bailey to return cow as well as the calf to the bailor. Termination of bailment. Termination of bailment is when the purpose is achieved. Suppose it is for a fixed period, then at the end of the period, if the subject matter is destroyed, if there is death, or if there is indefinite period, then if a party gives notice of termination. Now let us do another case study on bailment. Rakesh and Mukesh are brothers and they are engaged in trading of cycles. Both are having separate business. Naveen, son of Rakesh, is studying in engineering in a college in Germany. Enthused by the technical excellence in cycle industry in Germany, where he is working as an intern, he invites his father. वो अपने father को invite करता है कि कहता है भाई पापा आप देखो यहाँ कितनी advancement है, ठीक है ना? To visit him in the month of June when the weather in Germany is superb. Rakesh asks his brother Mukesh to take care of his cycle business. उसने कहा कि भाई आप भी मेरी दुकान भी देख लेना, दोनों की दुकानें साथ साथ में हैं, ठीक है? While he is on vacation to Germany, the cycle business of both the brothers is insured. दोनों का business insured है. While Rakesh is in Germany, the grandsons and granddaughters of Mukesh visit him in India. Mukesh has asked his son Nitin to take care of the business of his uncle Rakesh. मुकेश ने अब अपने बेटे को बोला कि वो अंकल की दुकान का भी ध्यान रखना. Besides this, Mukesh also employs Ramu as a worker to attend to daily business at the shop owned by Rakesh on a monthly remuneration of 10,000 rupees per month. Nitin lets the grandsons and the granddaughters of Mukesh to take a joyride on the sports cycle lying in godown of Rakesh. Unfortunately, an old lady is badly hurt while the children are taking the joyride and succumbs to her deadly injuries due to excessive bleeding on way to hospital. Road Accidents Claims Tribunal awards a compensation of rupees 10 lakhs, okay, which has to be paid to the legal heirs of old lady by Mukesh. Okay. Rakesh extends his stay in Germany for another couple of months and intimates Mukesh that he will return to India in the month of January. बोला मेरा तो मन लग गया, मैं जनवरी में वापस आऊंगा. मुकेश ने उसको बताया भाई ऐसे ऐसे एक्सीडेंट हो गया, वो बच्चे साइकिल चला रहे थे और उन्होंने ओल्ड लेडी को हर्ट कर दिया, तो हमें तो कंपनसेशन देना पड़ेगा. So Mukesh briefs him about the sad incident that took place. Rakesh assures him not to worry. उसने कह दिया कोई बात नहीं, जैसे बच्चे आपके हैं वैसे मेरे हैं, जो हो गया सो हो गया, ठीक है ना? But ask him to be careful in future. अब उसने बोला भाई आगे से केयरफुल रहना, ठीक है? While dealing with children, भाई बच्चों को देखो, थोड़ा ध्यान रखो. During Diwali season, Nitin, son of Mukesh, takes the grandchildren for Diwali puja to the godown of his uncle Rakesh. ठीक है, अपने यहाँ पूजा करनी थी तो वहां भी पूजा करने ले गए. और पैकिंग के लिए साइकिल्स के लिए ना वो बोरियो वाला कपड़ा होता है, हेसियन क्लॉथ कहते हैं उसको. हेसियन क्लॉथ इज लाइंग इन द गोडाउन व्हिच कैचेस फायर ड्यू टू द फायर क्रैकर्स अनलिस्ड बाय द नॉटी चिल्ड्रन. बच्चों ने क्या किया, वहीं दुकान में पटाखे चला दिए और वो हेसियन क्लॉथ से दुकान में आग लग गई. गोडाउन कैचेस फायर एंड ए लॉस ऑफ 25 lakhs is claimed from the insurance company. Since the fire was caused due to negligence, the insurance claim is rejected by the insurance company. ठीक. Now, considering the above situation and keeping in view the provisions of Indian Contract Act and Sale of Goods Act, let us try to answer these questions. Pehla, whether Mukesh can be held liable for the loss caused due to payment of accident claim, whether he can claim this amount from Rakesh. पहला क्वेश्चन, मुकेश और राकेश ब्रदर्स हैं, राकेश गया हुआ है जर्मनी, ठीक है? दोबारा बता देता हूं केस. तो ये लॉस जो है मुकेश बियर करेगा या राकेश बियर करेगा? मुकेश ने बताया था ऐसा ऐसा हो गया, राकेश ने कह दिया कोई बात नहीं, ठीक है, लेकिन आगे से केयरफुल रहना. तो इसका मतलब ही हैज एक्सेप्टेड दैट लायबिलिटी, ठीक है ना? तो वो राकेश से क्लेम कर सकता है. Whether Mukesh can claim reasonable expenses for looking after the business of Rakesh while he was outside India, क्योंकि उसने एक PNB रखा हुआ है, उसके लिए रखा हुआ ना 10,000 रुपए पर मंथ, तो
हाँ
क्या
वो एक्सपेंसेस
ये-
बेयर करने
हाँ
कर-
ये क्लेम कर सकता है ना? तो ये बेलमेंट में लिखा हुआ है। पहले सबसे पहली बात तो ये कॉन्ट्रैक्ट ऑफ बेलमेंट है, क्या है ये? वेदर इट इज ए कॉन्ट्रैक्ट ऑफ बेलमेंट?
कॉन्ट्रैक्ट ऑफ बेलमेंट सर।
यस, बिल्कुल ठीक है। एंड मुकेश कैन क्लेम रीजनेबल एक्सपेंसेस for looking after the business of Rakesh while he was outside India. Who will bear the loss caused due to fire since no claim was received from the insurance company? अब बाद में जो लॉस हो गया,
मुकेश सर,
हाँ मुकेश बियर करेगा, क्योंकि उसने बता दिया था, उसने क्या क्या
आगे नहीं करना ये।
हाँ उसने कह दिया था भाई not to worry but asked him to be careful in future while dealing with children. ठीक है ना? Rakesh agrees to reimburse the compensation paid to the old lady but asks Mukesh to pay him for the loss caused due to fire. If Mukesh does not pay, can Rakesh file a petition for insolvency of Mukesh? ये पिटीशन फाइल कर सकता है क्या? भाई ये किस नेचर का है? These are damages for breach of contract basically. ये डैमेजेस नहीं तो है ना?
क्वेश्चन 1 एक बार फिर से डिस्कस करेंगे सर, थोड़ा वो क्लियर नहीं हो।
क्वेश्चन 1 में ये है कि भाई राकेश चला गया जर्मनी, राकेश और मुकेश ब्रदर हैं, दोनों की दुकानें आसपास में हैं, तो राकेश ने बोला मुकेश को भाई मेरी दुकान का भी ध्यान रखना। ठीक है, अब वो मुकेश के कोई ग्रैंड डॉटर ग्रैंड चिल्ड्रन आए हुए थे, उन्होंने वो साइकिल चलाने लगे, एक ओल्ड लेडी हर्ट हो गई और फिर वो उसकी डेथ हो गई। मोटर एक्सीडेंट्स क्लेम ट्रिब्यूनल ने कंपनसेशन अवार्ड किया। मुकेश ने राकेश को फोन पे बताया, राकेश का फोन आया, वो कह रहा भाई अभी तो मैं और 6 महीने जर्मनी में हूं, तो उसने बताया भाई ऐसे ऐसे हो गया था, तो राकेश ने कहा कोई बात नहीं, जो हो गया सो हो गया, आगे से ध्यान रखना। ये केस है, तो अब क्या ये क्लेम कर सकता है राकेश से या नहीं?
Then he can claim from Rakesh and Rakesh has to pay it means sir.
यस,
Because
हाँ नहीं, अब बाद में उसने कहा, बाद में दोबारा भी गोदाम में आग लग गई क्योंकि बच्चे वहां चले गए, बच्चों ने वहां पटाखे छुड़ा दिए दुकान के अंदर, वहां बोरियों का कपड़ा रखा हुआ था एशियन क्लॉथ, उसमें आग लग गई। इंश्योरेंस कंपनी ने वो क्लेम दिया नहीं क्योंकि नेग्लिजेंस से था। तो अब इस लॉस के लिए कौन जिम्मेदार है, राकेश या मुकेश?
फायर का तो मुकेश इज
हाँ
रिस्पॉन्सिबल।
मुकेश ही जिम्मेदार है, ठीक है ना? अब बात यह है कि क्या राकेश इसके लिए इंसॉल्वेंसी पिटीशन फाइल कर सकता है या नहीं, वेदर इट इज अ डेट और नॉट?
इट इज डेट ना हो तो भी कर सकता है सर, बिकॉज मुकेश फायर उसको बोला था कि आपको ध्यान रखना है, फायर
हाँ,
हो गई
हम्म।
तो आस्क फॉर द पेमेंट फ्रॉम मुकेश।
अच्छा थोड़ा सा ना अब ऐसा करते हैं, जरा पीएफ एक्ट के बारे में देख लेते हैं। पीएफ एक्ट के बारे में आप कुछ क्वेश्चन बताइए मेरे को, पीएफ एक्ट वैसे ही डिस्कस करते हैं, ठीक है? पीएफ और ईएसआई डिस्कस करते हैं, क्योंकि पीएफ और ईएसआई शायद डिस्कस किया भी नहीं। पहले तो ये बताइए कि दिस पीएफ एक्ट अप्लाइज कि कितने वर्कर्स होने चाहिए उसमें, हाउ मेनी पर्सन शुड बी देयर फॉर दिस पीएफ एक्ट टू अप्लाई? 10, 20 कितने होने चाहिए?
पावर वाला है तो 10 है, अदरवाइज
20 sir.
10 and 20 is there sir, without power 10, otherwise 20.
पावर वाला तो ईएसआई में नहीं है, पीएफ में है क्या? और पीएफ एक्ट के ऑफिसेस पर लगता है या फैक्ट्रीज पर ही लगता है सिर्फ?
ये सर ट्रेडिंग बिजनेस में भी लगता है।
सभी तरफ लगेगा सर।
Yes, so this PF Act it applies to factories and other notified establishments employing 20 or more persons. ठीक है?
तो इसमें एक क्वेरी है, ओवर टाइम में पीएफ एलिजिबल, मतलब इज पीएफ टू बी पेड ऑन ओवर टाइम, इसमें क्लैरिटी हो सकती है? क्योंकि वहां पे थोड़ा कंफ्यूजन।
नहीं, स्पेसिफाइड है। स्पेसिफाइड में क्या है? बेसिक वेजेस है, डियरनेस अलाउंस है, रिटेनिंग अलाउंस है, कैश वैल्यू ऑफ फूड कंसेशन। ये 4 चीजें कवर्ड है।
हाँ नहीं, अगर ईएसआईसी में अगर देखते हैं ईएसआईसी एक्ट, तो उसमें ओवर टाइम के ऊपर में ओवर टाइम इज कंसिडर्ड एज ए पार्ट ऑफ ईएसआईसी।
अभी हम पीएफ डिस्कस कर रहे हैं, पहले पीएफ को कर ले। पीएफ में देयर आर 4 थिंग्स। क्या क्या कवर्ड है? बेसिक वेजेस, डियरनेस अलाउंस, रिटेनिंग अलाउंस एंड कैश वैल्यू। तो पहले कुछ कुछ ब्रीफ डिस्कस करते हैं इसका, पीएफ एक्ट का, देन वील टेक क्वेश्चंस। तो पीएफ एक्ट में सबसे पहली बात आपने ध्यान रखनी है, इट अप्लाइज टू फैक्ट्री एंड अदर नोटिफाइड एस्टेब्लिशमेंट आल्सो एम्प्लॉइंग 20 और मोर पर्सन्स। So once an establishment is covered, its departments and branches wherever they are covered. ठीक है? Once establishment is covered, it continues to get covered even if the employment goes below 20. आपने जब लिया तब 20 थे, बाद में कम हो गए, तो भी it will continue to be covered. ठीक है? इसमें there are 3 schemes: employees provident fund, employees pension scheme, and employees deposit linked insurance scheme. These are the 3 schemes covered. ठीक है? Exemption can be granted to certain establishments or employees. Contribution are made both by the employers and employees, and the fund is administered by the Central Board of Trustees. Both employer and employee contribute at the rate of 12% of pay to Provident Fund. In some establishments, like any establishment employing less than 20 persons, SIC units, jute industry, beadi industry, brick industry, coil industry, other than the spinning sector, guar gum factories, contribution is 10%. Normally it is 12%. Now 8.33% of contribution of employer goes to family pension fund, and balance is credited to employee's PF account. Entire contribution of employee is credited to his PF account. Interest is paid on this amount. Since last 4 years, interest is 8.5%. Employee whose pay is less than 15,000 per month is covered under the act. So pay includes basic wages, dearness allowance, retaining allowance, and cash value of food concession. The limit was, पहले ये लिमिट होती थी 6,500 up to 2014, अब ये लिमिट है 15,000. If an employee is a member, he continues to be a member even if his pay becomes more than 15,000. Employer is liable to pay contribution only on the salary of 15,000. Though employer can voluntarily contribute more as extra employee benefits. कई बार क्या होता है, एम्प्लॉयर कहते हैं भाई हम तो 15,000 तक पर ही कंट्रीब्यूशन देंगे, ऐसा हो सकता है. ठीक है? लेकिन अगर वो ज्यादा पर चाहे तो ज्यादा पर भी दे सकते हैं. Employee can voluntarily pay contribution on pay above rupees 15,000. In addition to PF contribution, the employer also has to pay administration charges. So presently it is 1.1% of wages. In case of exempted establishments, the employer has to pay 0.18% of wages as inspection charges. Contribution and administration charges are to be paid within 15 days from the close of the month. If employer delays payment, interest can be recovered from him. Employer has to submit consolidated annual contribution statement of PF in Form 6A for March paid in April to February paid in March of current year, along with contribution card of each employee for same period in Form 3A by 30th April. Whether early withdrawal is allowed from PF? Yes, early withdrawal is allowed. There are certain purposes for housing, marriage, illness. It is permissible. Member is entitled to get pension after retirement after completion of 58 years of age. Pension depends upon the number of service of number of years and is average salary of last 12 months. No pension is available for less than 10 years of service. Only contribution is returned with slightly reduced interest. अब थोड़ा सा ESI पर देख लेते हैं. ESI में क्या है? ESI Act applies to factories. It can be made applicable to shops also. ठीक है? So factory means any premises where manufacturing process is carried out and persons employed are at least 10. Once a factory or establishment is covered, it continues to be covered even if the number of employees reduce. ठीक है. अच्छा, ESI में कितनी लिमिट है? ESI में लिमिट है 21,000 पर मंथ. ठीक है, विद इफेक्ट फ्रॉम 1/1/2017. पहले लिमिट थी आपकी 15,000, अब ये लिमिट हो गई है 21,000 पर मंथ. एम्प्लॉय कंट्रीब्यूशन कितना होता है ESI में? एम्प्लॉय कंट्रीब्यूशन होता है 1.75% ऑफ वेजेस. ठीक है, राउंडेड टू नेक्स्ट हायर रुपी. एम्प्लॉयर कंट्रीब्यूशन कितना है इन केस ऑफ ESI? एम्प्लॉयर कंट्रीब्यूशन इज 4.75% ऑफ वेजेस. और ये कंट्रीब्यूशन कब तक देना है आपको? विद इन हाउ मेनी डेज? 15 days or 21 days in case of ESI? 21 days. PF आपको देना है within 15 days. ESI
15
देना है
days.
within 21 days from close of the month. If the contribution is not paid in time, interest at the rate of 12% is payable. अच्छा,
उसमें सर
यहाँ पर
PF में 8.5 है क्या इंटरेस्ट?
PF का जो 8.5% है ना, वो इंटरेस्ट है जो आपके कंट्रीब्यूशन पर मिल रहा है. जो कंट्रीब्यूशन पर मिल रहा है वो 8.5.
ओके ओके.
हाँ.
और ये इंटरेस्ट ऑन नॉन पेमेंट कितना है सर ESI का? अभी आप बता रहे थे ना
12%. वेजेस का क्या मतलब है यहाँ पर? वेजेस मींस ऑल रिमनरेशन पेड और पेएबल इन कैश टू एम्प्लॉई अकॉर्डिंग टू टर्म्स ऑफ कॉन्ट्रैक्ट ऑफ एम्प्लॉयमेंट एंड इंक्लूड्स एनी पेमेंट मेड टू एन एम्प्लॉई इन रिस्पेक्ट ऑफ पीरियड ऑफ ऑथराइज्ड लीव. ठीक है, lockout, layoff, strike, which is not illegal, and other additional remuneration paid at interval not exceeding 2 months. It does not include contribution paid by employer to any pension fund or provident fund, traveling allowance, reimbursement of expenses made by nature of employment of the employee gratuity. Thus wages include, यहाँ पर क्या क्या आ जाएगा? दोनों में फर्क है, जो जयंत जी का सवाल था. तो यहाँ पर वेजेस में it includes basic pay, dearness allowance, CT compensatory allowance, payment of day of rest, overtime wages, house rent allowance, incentive allowance, attendance bonus, meal allowance and incentive bonus. इसमें ये है ना. तो यहाँ पर वो ओवरटाइम इंक्लूडेड है, बट PF में ओवरटाइम इंक्लूडेड नहीं. मैं इसको बोलूंगा अपने स्टाफ को, किसी को स्कैन करके आपको भेज देगा. ये लेटेस्ट है हमारे, मेरे पास ये लेबर लॉज है, लेबर लॉज की बुक है ये, है ना. उसमें से पढ़ रहा हूँ. तो आई विल गेट इट स्कैन 2-3 पेजेस जो भी इंपॉर्टेंट है ना. तो अभी मैं देख रहा था, ऑफिस में पड़ी हुई थी बुक में ले आया, मैं कहा चलो आज थोड़ा सा डिस्कस कर लेंगे इसको.
सर एक हमारे एक यहाँ पे नागपुर में मित्र है, ही अपीयर्ड फॉर एग्जाम, अभी क्लियर नहीं किया उन्होंने आईपी का. तो ही सेड ही हैड अ क्वेश्चन कि दैट ओवरटाइम का जो पेमेंट किया नहीं, बट दैट इज नॉट PF रिलेटेड, वो तो ओवरटाइम का था उसमें. ओके ओके, नहीं दैट वाज टोटली डिफरेंट. कुछ गलत बोला होगा, वो PF रिलेटेड नहीं था वो. उनका सवाल था कि परफॉर्मेंस अलाउंस, मेडिकल अलाउंस OT में ऐड किया ऐसा कुछ, तो शायद उसने कुछ मिक्स करके मिसअंडरस्टैंड किया होगा, पता नहीं.
हो सकता है, बट देखो बेसिक अंडरस्टैंडिंग क्या है कि ओवरटाइम अलग अलग दोनों को स्पेसिफाई किया हुआ है, क्या क्या इंक्लूड है वेजेस में. PF में वेजेस का अलग से दिया हुआ है, क्या क्या इंक्लूडेड है मैंने आपको पहले भी बताया, मैं दोबारा.
यस यस यस,
है ना, वहां पर क्या क्या इंक्लूडेड है?
बेसिक अलाउंसेस एंड बेसिक DA अलाउंसेस.
हाँ, बेसिक वही है. यहाँ है बेसिक वेजेस, डियरनेस अलाउंस, रिटेनिंग अलाउंस एंड कैश वैल्यू ऑफ फूड कंसेशन. ये 4 चीजें इंक्लूडेड है PF में. ठीक है, और ESI में बहुत लंबी चौड़ी लिस्ट है. ESI में क्या क्या इंक्लूडेड है? ESI में इंक्लूडेड है आपका बेसिक पे, डियरनेस अलाउंस, सिटी कंपनसेटरी अलाउंस, पेमेंट ऑफ डे ऑफ रेस्ट, ओवरटाइम वेजेस, हाउस रेंट अलाउंस, इंसेंटिव अलाउंस, अटेंडेंस बोनस, मील अलाउंस, इंसेंटिव बोनस. अच्छा, जब एम्प्लॉय ज्वाइन करता है तो डिक्लेरेशन लेना होता है आपको ESI के लिए फॉर्म 1 के अंदर. ठीक है, एंड दिस डिक्लेरेशन शुड बी सबमिटेड विद इन 10 days टू ESI ऑफिस. रिटर्न ऑफ कंट्रीब्यूशन आपकी जाती है फॉर्म 5 के अंदर. रिटर्न इज टू बी सर्टिफाइड बाय चार्टर्ड अकाउंटेंट इफ द नंबर ऑफ एम्प्लॉयज आर 40 और मोर. If the number of employees are less than 40, self-declaration is to be made by the employer regarding maintenance of records and registers. एनुअल डिक्लेरेशन देना आपको फॉर्म 01A के अंदर, ठीक है। अच्छा, फैक्ट्रीज एक्ट में वो जो आप बता रहे थे ना तविंदर पाल जी, वो आप फैक्ट्रीज एक्ट से देख रहे थे। फैक्ट्रीज एक्ट में है वो पावर और नॉन पावर। तो फैक्ट्री में क्या है, फैक्ट्रीज एक्ट में फैक्ट्री मीन्स एनी प्रीमिसेस वेयर 10 or more workers are working and manufacturing process is carried out with the aid of power, ठीक है। 20 if manufacture is without the aid of power. However, it does not include a mine, a mobile unit belonging to armed forces, railway running shed, or a hotel, restaurant, or eating place. For computing number of workers, workers in different shifts will be taken into account. ठीक है। If the employment is less than these numbers, the units gets covered under Shop and Establishment Act. ठीक है। अगर जैसे 10 से कम है या 20 से कम है तो वो फिर कहाँ कवर होगा, शॉप्स एंड एस्टेब्लिशमेंट एक्ट। फैसिलिटीज है, ये फैसिलिटीज के ऊपर कई बार क्वेश्चन पूछ लेता है वो, फैसिलिटीज के ऊपर क्वेश्चन कई बार एग्जाम में पूछता है वो। फॉलोइंग फैसिलिटीज आर रिक्वायर्ड टू बी प्रोवाइडेड बाय लार्ज फैक्ट्रीज, ठीक है।
सर कोई
एम्बुलेंस
डेफिनेशन है क्या लार्ज फैक्ट्रीज
वो दे दिया ना, वो आगे दे रहा है ना। एम्बुलेंस रूम है, इफ 500 और मोर वर्कर्स आर एम्प्लॉयड, अगर 500 है उससे ज्यादा है तो आपको क्या करना है, एम्बुलेंस रूम रखना है। कैंटीन इफ 250 और मोर वर्कर्स आर एम्प्लॉयड। ये बहुत बढ़िया इसने दिया हुआ है इस किताब में ना, इसमें 2-2, 3-3 पेज में सारा इन्होंने दिया हुआ है, अच्छी तरह से दिया हुआ है और लेटेस्ट है ये, है ना। कैंटीन है इफ 250 और मोर वर्कर्स आर एम्प्लॉयड, इट शुड बी सफिशिएंटली लाइटेड एंड वेंटिलेटेड एंड सुटेबली लोकेटेड। रेस्ट रूम्स है या शेल्टर्स है विद ड्रिंकिंग वाटर व्हेन 150 और मोर वर्कमैन आर एम्प्लॉयड। क्रैचेस है, क्रैच पे एक बार सवाल भी पूछ चुके हैं। क्रैचेस है इफ 30 और मोर वुमेन वर्कर्स आर एम्प्लॉयड, ठीक है। फुल टाइम वेलफेयर ऑफिसर इफ फैक्ट्री एम्प्लॉयज 500 और मोर वर्कर्स। सेफ्टी ऑफिसर इफ 1000 और मोर वर्कमैन आर एम्प्लॉयड, ठीक है।
सर ये फीमेल वर्कर में जो क्रैश का इंतजाम है वो कितने वर्कर में होता है?
30 और मोर वुमेन वर्कर्स आर एम्प्लॉयड, सेक्शन 48 ऑफ फैक्ट्रीज एक्ट।
30 ladies हैं मगर only two kids are there. Suppose infant kids are there, 1 or 2 or 3. Then even then they have to do it.
हाँ वो तो करना ही पड़ेगा, वो तो क्रैच बनाना ही पड़ेगा ना। सेक्शन 48 है, बाकी डिटेल में पढ़ना चाहे तो सेक्शन 48 में पढ़ सकते हैं फैक्ट्रीज एक्ट में, फैक्ट्रीज एक्ट में जाकर के। ये अलग अलग सेक्शंस हैं, वो लोग उस सेक्शंस पर है, यहाँ बेसिक इंफॉर्मेशन इन्होंने दे रखी है। ओवर टाइम कब मिलता है, इफ ए वर्कर वर्क्स बियॉन्ड 9 hours a day और 48 hours a week, ओवर टाइम वेजेस आर डबल द रेट ऑफ वेजेस, सेक्शन 59 सबसेक्शन 1। ए वर्कमैन कैन नॉट वर्क इन 2 factories, there is a restriction on double employment, ठीक है। However, overtime wages are not payable when the worker is on tour. Total working hours including overtime should not exceed 60 in a week, and total overtime hours in a quarter should not exceed 50. Register of overtime should be maintained. Industrial Disputes Act. मिनिमम वेजेस एक्ट, मिनिमम वेजेस एक्ट तो एक्चुअली स्टेट वाइज है, तो आपको स्टेट वाइज इसको देखना पड़ेगा। मैटरनिटी बेनिफिट एक्ट है, बहुत सारे उन्होंने क्या किया, वो तो लेबर लॉज दे दिया वहां पर, तो लेबर लॉज में तो सारे लॉज आ जाएंगे आप, लेकिन कुछ कुछ याद रहेगा तो आपको कई बार सवाल उसमें से आ सकता है। पेमेंट ऑफ बोनस एक्ट, ये बोनस एक्ट में क्या प्रोविजन है, पहला तो किस पे ऊपर एप्लीकेबल है ये। सो एक्ट इज एप्लीकेबल टू एनी फैक्ट्री एम्प्लॉइंग 10 or more persons, in case of power or other establishments 20 or more persons. Minimum bonus payable is 8.33%, maximum at 20%. Bonus is payable annually within 8 months from close of accounting year. Bonus is payable to all employees whose salary or wages does not exceed 21,000. ठीक है, पहले ये लिमिट थी 10,000. provided they have worked for at least 30 days in the accounting year. However, for calculation of bonus, maximum salary of 7,000 or the minimum wages for the scheduled employment are fixed by the appropriate government, whichever is higher. चलो कुछ कुछ तो याद हुआ है ना। ये मैं शेयर कर दूंगा आपसे, जो जो इंपॉर्टेंट चीज है ना, मतलब मैं आपसे 5-7 पेजेस शेयर कर दूंगा, इसमें उतना ही पढ़ लोगे ना तो हो सकता है उसमें से कुछ सवाल आ जाए आपको। आज वो कितने बजे है?